Hello, hello, hello. This is Attorney Mike Revan coming to you from Chicago. As usual, we're waiting for Judge Middleton to start his call in 3B, but I thought we would just go and watch Judge. What is this? I thought we'd go watch Judge Fink ride the struggle bus while we waited.
Hello,
Hi.
what is your name, please?
D'Angelo Armstead.
Okay,
Can I take my mask off or no?
it's okay with me if the corrections officers are okay with it.
They said it
When
was.
3B
Okay.
goes live.
Mr. Armstead, you have 4 files here. You missed a court date back in 2018 on 2 of them,
Yes.
and on the other 2, those are the 2 felonies. On the 2 misdemeanors, you also missed court dates in 2018.
One of them, he just owes money because he was sentenced. The other one.
Okay.
But excuse me, Your Honor, I would like to state if I knew about the court dates, I would have went to them. I didn't get
I don't know what that means because
Mr.
I know you
Armstead,
did.
I'm going to address this magistrate Fink in a moment, sir.
I'm sorry, I just
Okay, let me get your contact information updated
It means
and
this,
call the
Judge.
cases, and then I can listen to what your lawyer has to say about that, okay?
Okay.
All right, I've got an address on Central Street in Ypsilanti. That's okay to get mail there?
Yes.
Phone number ends in 5723. Is it okay if the court uses your phone number to have contact with you?
Yes.
And okay to
course.
use your email to have contact with you?
Yes. The email would be better, but yes.
With each stream.
Okay. All right, thank you. So we have State of Michigan versus Armstead 18F21997 and 18F21670, 18F21104, and City of Ypsilanti versus Armstead 1820511. Your office was previously appointed on
Love
all
it.
files. Mr.
Thank you,
Lebo, you
Jojo.
may proceed when you are ready.
Thank you, Your Honor. Missed my mute button there. As
Judge,
Your Honor knows, these
You
are
know
all
you got to zip that down when you wear it,
failure to
right?
appears in various related cases from 2018 when Mr. Armstead was 17 years old. At the time, he had been under the impression that he had closed off these cases when he made a $1,700 payment in 2018, and he informed that he has not been contacted about these court dates and was unaware that he had missed these court dates until he was in a vehicle at work while a passenger and was pulled over when the officer had asked to see his ID, and at that time took him into custody for these warrants. Mr. Armstead is employed full-time with Hillside Removal and has been for 2 months. He's been a lifelong Michigan resident except when he briefly lived in Wisconsin, where he has now moved back to Ypsilanti. We would request a personal reconnaissance bond and new court case in this matter.
When I don't see any evidence that he made any kind of payment on any of these files. So I don't know what that means.
Judge Middleton on?
When you're saying he made a $1,700 payment, because none of these cases.
Is that what you're trying to tell me?
None of these cases actually are that. They don't have any, he hasn't been convicted on any. Well, one of them, I think he pled guilty, but the other ones, I don't believe he's been convicted of anything. So there's nothing for him. There wasn't anything for him to pay.
Okay, looks like we're going to the Judge Middleton call here. Let's do it. Okay, is that Deborah in there? Well, this is no good. That was a premature switch. I wonder if they'll try this.
You didn't say the cat jumped on his wiener, did you?
I think that's the only defense that has a chance. Yeah, it's funny. I'm reading the chat. I'd watch for a second to see Judge Middleton move because I wasn't sure if this was just a static image. Oh, I've got more. Don't worry.
Have you ever had any history of substance abuse issues?
I smoked a lot of weed.
I know. I miss Debbie having her own Hollywood Square there.
Hey, at least he was thinking about protection.
I mean, from who? Ground?
I mean, he don't know what's on this ground.
Look at baby oil. Maybe that's what I touched. Maybe that was that.
I hope it was baby oil.
I can email him copies of this report because so I just haven't bought it and start emailing the report to.
I hear Deborah.
I'm not in here, judgeable.
It's about to happen.
Your Honor, it's because you know.
Y'all out there. Y'all.
You find there's an affidavit in there.
Okay. Do you need to?
Are we ready for Mr. McEntee?
Yes.
We have a no contest plea.
They'll probably bring one too.
That means no hearing of any substance, but we'll see. We'll see. Yeah. That's where we're headed. I was thinking about doing a shirt that says pre-trials, screaming goats, and thruples. If you know, you know. Okay, so even a no contest plea, I want to see what's going on, and I want to see if the victim showed up. All right. Well, then I'll go back.
Y'all out there bunny hopping. I'm out here dealing with a naked man humping the ground.
I'm out here dealing with a naked man humping the ground. It's so good. It's so good. Oh. But that's why this is taking forever, because they're in the back hammering this thing out. I wonder if this. I wonder what his conditions will be.
Stay out of Fulton County, sir. The only reason you're going to come to Fulton County is court or to see your lawyer. Not even get gas. Can't even stop at Chick-fil-A. Stay.
Hey, Judge, what's going on?
Hi, we're ready for Mr. Mack.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
She's there? Okay, where is she? I wouldn't recognize her. I don't know what she looks like. But if there's a woman in court that's not Deborah, there's a good chance that's her. Absolutely. Now that is one of the coolest things I've ever heard.
Yeah, you're on a relay approach.
Yes, the live feed is on. Let me turn it off.
No, it's.
The old Nutty Adventure. It's a classic already.
She just sent it. I haven't looked at it.
I haven't actually seen it. I don't know if there's a charge.
There's an affidavit of probable cause in the file.
I have no doubt.
There's an affidavit of probable cause prepared by Jason, which could suffice, I'm assuming, as a factual basis.
Sure. Thank you.
Thank you, Your Honor.
Let's go on the record.
Yes. Is that him?
This is file number 222359FY. It's entitled People versus Jack McEntee III. That's you, sir?
Yes, sir.
This isn't the case.
Mr. McEntee, yeah, he knows me, but I did need to identify him for the record. He's here with his attorney, Trevor Mavio from the Hills Law Firm. Also present is Deborah Davis from the prosecuting attorney's office.
That's naked.
Mr. McEntee
Alan.
is charged with 2 counts of criminal sexual conduct at the first degree with personal injury to the victim. 3 counts.
Oh, thank you.
4th count of assault with intent to commit great bodily harm. Criminal sexual conduct first degree is a felony punishable by up to life imprisonment. Mr. McEntee has been in custody.
No, it isn't. So I don't.
14 days. I was advised.
This no contest plea might be this guy's, not Schwartz's. I can't tell yet.
Status here, Ms. Davis.
Your Honor, the people have discussed a plea offer with the victim's input and Detective Auden's input. And we have offered that if the defendant pleads to
Never.
1 count of attempt CSE in the 4th degree and 2 separate counts of domestic violence first offense, we would dismiss the remainder.
Well, let's talk about that. Criminal sexual conduct first degree, as I indicated, is a felony punishable by up to life imprisonment. Assault with intent to commit great bodily harm is a felony punishable by up to 10 years imprisonment. Attempted criminal sexual conduct 4th degree is a misdemeanor. It's punishable by up to a year in jail and I believe a fine of up to $1,000. Domestic violence are misdemeanors. We take hundreds of those pleas, unfortunately, every year. That's a misdemeanor punishable by up to 93 days in jail. and a
Which is
fine
similar to
of $500.
Californication.
So, Mr. McEntee, as I understand it, you would enter a plea by no contest. And I guess that could be for civil liability. By pleading no contest, you don't admit what happened, but you also don't deny what happened. You allow or accept that a conviction would enter. Do you understand?
Yes, sir, Your Honor.
And you would be entering a no contest plea to one criminal sexual conduct attempt in the 4th degree and 2 counts of domestic violence.
I'll try to turn it up.
Understanding?
Yes, sir, Your Honor.
Mr. Mayval, you confirm that?
Yes, Your Honor, that's accurate.
All right, Mr. McEntee, do you understand that if you do plead no contest to these charges, you will be giving up your right to have a trial in front of a judge or a jury? Do you understand that?
Yes, Your Honor.
Is that
At
better?
a trial, you would have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. You'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to be presumed innocent if and until the state was able to prove your guilt beyond reasonable doubt, and you'd have a right to have an attorney. You've actually retained one. That's fine with us. If you'd asked me, I would have appointed one for you as well. Now, I propose to use the affidavit of probable cause that was prepared by Detective Sergeant Jason Auten at the
How about the
Sheriff's
affidavit of truth?
regarding this matter. Is that acceptable, Ms. Davis?
Yes, Your Honor.
No objection.
All right. It alleges that on or about October 9th
Thank you.
in Borough Township, that you were at that location with someone who was a former girlfriend. We'll just call her Chelsea. And she indicated that you came to her house to watch Netflix, and
Netflix and chill gone wrong.
some contact, which
Gone wrong.
to be more intimate. They began to wrestle playfully. She said she didn't want to.
Awkward.
Things turned more serious. Jack tried to remove her panties and she tells him, no, stop. Then proceeds to place his hand over her mouth, would prevent her from speaking or making any sound. That's sufficient for one count of domestic violence.
Rob, even Rob can screw up a screaming goat. I'll set him straight.
She then tried to force his hand off her mouth and he put his hand over her mouth. She said she couldn't breathe and he told her to breathe through her nose.
Yow.
Then she fell asleep, and when she woke up, the defendant had placed his penis inside her vagina.
Oh, good Lord.
That is certainly sufficient for attempted criminal sexual conduct in the 4th degree.
Doesn't sound like an attempt to me, but okay.
Counts of domestic violence and a sexual unwanted contact.
Indeed.
You have the same report?
I sent those, it's the last, I think it's noted as other evidence. It's 113 pages and the same report is included in that.
Well, I think we're gonna need to get more input for it. I don't want to just shoot from the hip to do this sentence.
Of course it isn't. It's a plea bargain.
I think I'd like to get a pre-sentence investigation. Does the temp CSC fourth require registration under the Registration Act?
Yes, Your
Come
Honor.
on, Judge.
Are you aware of that?
First, you call the wrong case,
Does that change your mind about plea?
and then it's not
No, Your
fun at all.
All right, let's find a place to put this. Are you available on February 6th at 11 a.m.?
Yes.
Yeah. You can't ask it, Bubba, but it's a fair question.
Your bond is set in the amount of $150,000. If this were another type of case, it would require that bond be canceled pending sentence. You've been able to post the bond, and I'm not going to reduce it, so I'm going to cancel the bond.
Your Honor, may I be heard on bond?
Yes?
Your Honor, my client's criminal history is limited to misdemeanors. He's got a solid work history and he lives locally in the area here. I was optimistic that I was going to be able to have a psychosexual evaluation done for the court's consideration. In light of the age of these allegations and the nature of them in general, I believe him to be a strong candidate for probation, and I'd like to have all the information available for the court that I possibly can in between now and February 6th.
Bubba, that could be the case. We don't know. We don't know the facts.
For bond commensurate to the reduced charges for which he's pled.
That's certainly the way it would be
As the local
defended.
address would be able to post something. The court's got other
And that's why we have a plea
available to it to assure his appearance, such as pretrial services, color-coded drug testing, even GPS tether. However, in light of the misdemeanor plea, I do believe a bond in the $10,000 to $20,000 cash or surety range is appropriate. Thank you.
Your Honor, this is not the first.
Thanks, Kurt.
For Chief McEntee has been in front of the court. He was just recently here for his sentencing. He has a history of drug use, and there's certainly a concern that having him out and about while awaiting sentencing could lead to more trouble for him. But I would leave that to the court's discretion based on what the court has knowledge of regarding Mr. McEntee's past and the allegations in this case. Thank you.
Mr. McEntee was recently here. He was not welcome in his parents' house. Went back there and there was a hullabaloo and it ended up in a resisting obstructing. In December of 2021, he was charged with resisting obstructing a police officer and open intoxicants. Pled to a misdemeanor of attempted resisting obstructing. He did complete his probation.
Just these allegations are 40 months old, Your Honor.
Yes, this occurred in 2019, but the factual basis, and he can't now say I didn't do it, he pled no contest. He raped this girl while she was asleep, so his bond is canceled. 40 months old or otherwise. He's gotten in much trouble between then and now, including a recent felony charge of resisting obstructing, reduced to a misdemeanor. He was not welcome in his parents' house. He has a substance abuse problem. He has some mental health issues that need to be addressed. And we're going to work on those, but I'm not just going to dump him out on the street. And the factual basis was a rape. So bond is canceled. We'll
Yep.
deal with it on February 6th. You get credit for all the time that you're served. All right, February 6th at 11.
Thank you, Your Honor.
Thank you, Your Honor.
Interesting, but not the vibe I was looking for.
Mr. McEntee, someone will be coming to see you out at the jail to help me with this pre-sentence report. And I would certainly appreciate any other documentation you've got for me.
Yeah,
I'd be very interested in seeing any reports that you've got.
Judge hit the nail on the head there.
Thank you for waiting. All right. Mr. Moore, did you get your other matters taken care of?
Yes, thank you.
All right, Deborah, I think is going to adjourn to her office and we'll be connecting from there.
Okay.
So, Your Honor, as far as Trooper testifying, do you want him in here? And then I can ask.
Well,
him-
we're under a little bit of unusual circumstance. You want to be remote. David, by circumstances, is remote. Perhaps we could use the Zoom room for testimony and then everybody will be on the same wavelength.
I would like to have Miss Akers here when we watch the body cam, because then I'm gonna ask her some questions about it.
Well,
So-
she's here in the courtroom with us.
Yes, so I didn't want to have everybody sequestered or something like that. But I can't play the video from my laptop because it's too large of a file. So I have it queued up and ready in my office. So if you wanted me to start with questions
No, that's
here-
fine. Why don't you come in remote?
Okay,
We'll put the trooper in the Zoom room.
okay.
David is in his penthouse apartment in the sky or somewhere. He's not on vacation, that's where he is, but he attempted to get out, but eventually he will.
Okay.
But he's here.
All right, I will put the trooper in the Zoom room.
All right. Jenny, you're welcome to stay right in here. You're gonna be able to see everything on this screen, all right?
All right, I would prefer staying here.
All right, very good. I'm going to take these files out to the clerks. I'll try not to beat the door. And we will start here in just one moment.
The wheels of justice are going to roll you right into the Wayne County Jail.
What? I don't know Judge Schwartz's court. That's just awful. We're doing law stuff, people. This is going to turn ugly. So I'm just getting it. I'm getting my screaming goat out now. I think this is going to go from bad to worse. Is there a downtown Three Rivers? Does such a thing exist? I'm from the state. I don't know that I've ever been to. I've never been to any of these places. I don't know where. I haven't been to White Pigeon, Three Rivers, Centerville. None of it. None of it. Ah.
What you gotta bring him in? All right, we do have a live feed on.
Turn yourself into jail right now.
You okay if I give my son a hug?
No, that's how people pass things back and
Oh, I'll
forth.
take my coat off. I don't
No,
mind.
no, you're fine. You just, they don't, as a rule, allow contact. All right, we are gonna go on the record here. This is file number 221805FY. It's titled People versus Ryan James Swartz. That's you, sir? That's correct. And we've met, but I want to identify you for the record. Because of the circumstances we discussed last time, your attorney, Mr. David Moore, is here remotely, and that was with your consent and mine. Deborah Davis is here at the courthouse. She is also remote. And
Yay!
Mr. Limbrecht is also here at the courthouse, and he's in the Zoom room. The complaining witness, Jenny Akers, is here in the courtroom with us. I was very concerned about her circumstance. I'm glad she's here.
We all were.
Address more of that. There's a bench warrant for her contempt for failing to honor a subpoena. We're gonna have to address that at some point.
Whew.
But she is here. The allegation in this case, Mr. Swartz, and let me pull this up.
Yep. We've got the eye roll cam. We're ready to roll.
Is that on or about August 22nd in Flowerfield Township out on Cranberry Lake Road, that you did make an assault upon Jenny Akers by strangulation or suffocation. That is a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. Count 2 is you made an assault upon her with an assault rifle, but without intending to commit the crime of murder or inflict great bodily harm. That is a felony punishable by up to 4 years imprisonment and a fine of up to $2,000. Third count is domestic assault or domestic violence, alleging that you made an assault upon Jenny Akers. That's a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. This is the time and date for a preliminary examination. We talked about this last time. A preliminary examination is a hearing to attempt to determine whether there's probable cause to believe the crime was committed, probable cause that he did it. He won't be, and you won't be found guilty or not guilty at this proceeding. It is simply a probable cause proceeding to see if there's enough evidence to remove the matter to the circuit court for further proceedings, including a trial, and I'm losing my voice. I apologize. Ms. Davis, are the people ready to proceed?
We are, Your Honor.
Mr. Moore?
Yes, Your Honor.
All right, Ms. Davis, you may call your first witness.
Your Honor, the people will call Trooper Andrew Liebricht.
Trooper, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
Thank you. Have a seat, and would you state your name and spell your first and last name for us?
My name is Andrew Liebricht. My first name is spelled Andrew. My last name is spelled Librecht.
All right, Ms. Davis.
Thank you. Trooper Liebricht, you work for the Michigan State Police as a trooper, correct?
Yes, ma'am.
And were you on duty for the Michigan State Police on August 22nd, 2022?
Yes, ma'am.
And on that date, were you called to an incident at 11672 Cranberry Lake Road in Marcellus?
Yes, I was, ma'am.
And is that located in St. Joseph County?
Yes, it is.
What was your understanding of why you were called to that address?
We were dispatched to a female that had disconnected from a 911 line. Sounded like there was a male yelling in the background of the phone. And was threatening the female. It sounded like a physical altercation. And at one point, the female at the end of the second 911 call stated that there was a gun involved.
So how long did it take you to respond to this incident?
From me, it was probably approximately 10 minutes from whenever I got dispatched the call.
Where did you go first?
I went directly to the residence.
And what did you find when you got to that residence?
Nobody was at the residence. Me and one of the deputies from St. Joseph County Sheriff's Office had to search the residence. We were unable to find anybody, but there were family pets at the home.
At
Say
what
that
point?
again, I didn't hear what you said. You searched the resident, you said there were family pets at the home?
Correct. There was, I believe, 3 dogs.
Inside?
Outside. There's a doggy door at one of the doors, and I think they came out.
Did you then clear the residence to see if there were any occupants?
Yes, we did, ma'am.
After that, what happened?
I was notified that our victim, Jenny Akers, was found down the road near the intersection of Mount Zion Road and Bent Road. She was out with one of the deputies.
Approximately how far is that location from the house?
Approximately half mile to 3/4 mile, I believe.
Did you go and meet with that complaining witness, Ms. Akers?
Yes, I did.
Describe to me her demeanor when you got to her.
She was very emotional. She was crying, and she was on the phone with somebody I did not know at the time. She seemed very distressed by the situation that had just occurred.
Do you know how close in time to the 911 call that it was that you came upon Ms. Akers?
I believe it was approximately 40 to 45 minutes around that time frame.
Were you wearing a body camera?
Yes, I was.
And did you activate that body camera during this investigation?
Yes, I did.
And did you provide a copy of that body camera to the prosecutor's office?
Yes, I did.
Thank you, Jordan.
And is it a true and accurate representation of what you observed that day? Has it been altered in any way?
No, it is not, ma'am. It is a true representation of what occurred.
Your Honor, I'd ask to, as the People's Exhibit 1, play a portion of the body-worn camera of Trooper Liebricht from August 22nd, 2022.
That it's happening.
Your Honor, I would object. I'd say this is hearsay. Number one, we have the complaining witness in the courtroom here today. She's present. she can testify as to what happened. Also, there was a 40 to 45-minute delay, so I don't believe that that qualifies as an excited utterance.
Deborah, what's your thought?
Your Honor, under the court rules regarding domestic violence situations, it was close in time. She was still under the stress of the event. According to the trooper, she was still upset, crying. She had apparently walked from the residence about half a mile. And I believe that it fits under the exceptions available for us to use. It is the best evidence of what happened.
What rule are you citing?
Oh.
I don't know the specific provision in Michigan, but that would make sense. That's what all these rule changes about 30 years ago or 25, 30 years ago were to carve out an exception to hearsay just for exactly this purpose when you have a witness that won't cooperate with you. And they do it at that time. What was mostly contemplated is statements made to officers. But here we have an actual video. But no doubt about it, she's saying he did all these bad things to me. So it's an out-of-court statement offered to prove the truth of the matter asserted. So to start with, it is absolutely hearsay. But it's an exception because it's known that DV victims rarely cooperate with investigations. Quite honestly, that's why these changes were made throughout the country.
Your Honor, under MRE 8032, for an excited utterance, there would need to be a startling event, and the resulting statement of the declarant must be made while under the excitement of that event that is caused. And I believe that the information provided by the trooper has established that.
All right, that's the traditional hearsay exception. I'm under MRE 8032. You also mentioned the domestic violence exception.
Yes, looking for that.
I won't let it happen again. I'll do this just to make up for it. Judge is going to overrule this objection and let it in, but he wants to make his record clean. He just wants to make sure he has his I's dotted and his T's crossed. I don't know that, but that's my gut feeling.
So the old-fashioned book here.
Having said that, Attorney David Moore is making, that's the objection you make. Whether it gets sustained or not, that is the objection you make if you're representing that client. So everyone's doing what they're supposed to be doing here.
Ms. Davis, is it MCL 768.27C?
Those are the sections.
C. I'm sorry, 27C3.
I haven't had
768.27C and then 3. And if that is the case, Your Honor, my argument would be we're not at trial, we're at prelim.
I don't do criminal, so I don't see any grand distinction between trial and prelim, but there may be. I got nothing on that because I do civil. So I don't know if they're doing some distinction. If anything, I would think that they would allow more evidence in, but I could be wrong.
Along with no notice has been provided.
I saw that question in the chat.
Requires notice. This didn't just sneak up and bite us in the ankle. I've been waiting to hear what their intention was.
Your Honor, we've made it clear that we were going forward and using the body cam at every proceeding that we have attempted to have with this case.
Seven 68, 27 A and B.
There are limits.
Domestic violence statutes.
Thank you.
768-27B, if the prosecuting attorney B2 intends to offer evidence under this section, the prosecuting attorney shall disclose the evidence, including the statements of all witnesses, or a summary of the substance of any testimony to the defendant not less than 15 days before the scheduled date of.
Oh, good
trial,
Lord. Here we go.
which isn't always possible on a prelim, or at a later time is allowed by the court for good cause shown. But the plaintiff is arguing just plain old 803.2 excited utterance. We've learned that there was an incident. I don't yet know what it is. It's sort of a chicken or the egg sort of thing. I may need to hear the body camera to see how excited she is. And perhaps the 911 tape. But there was a call. The officer got there as fast as he could. 10 minutes to Cranberry Lake is pretty good from anywhere. Then they had to locate the victim, and within a very short time of that, the officer was talking to her and she indicated she was distraught. 803.2, the traditional excited utterance hearsay exception, states, statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. In this case, the allegation is he attempted to strangle her and threatened her
That's
with a
enough.
gun. And this was.
That's enough, Judge. Overruled.
Officer interview. We don't know what the other officer said, the deputy that stopped her, but for purposes of preliminary examination under the excited utterance exception to hearsay, I will allow this evidence. I'm not going to rely on 767 28 or 27. 768.27, excuse me. Let me get back to it. There may be an issue regarding notice. Obviously, she had indicated they were going to attempt to produce this evidence. We tried to have this prelim on 2 previous occasions, but were unsuccessful. At any rate, for purposes of preliminary examination, I find this is an excited utterance. I will overrule the objection and the evidence may be introduced.
Thank you, Your Honor.
Very clever, Lynn.
Trooper Liebert, can you see the still image here?
Yes, I can, ma'am.
And is this your body cam that you were wearing on August 22nd, 2022?
Yes, it is, ma'am.
All right. And we're starting, for the record, we're starting at 35:56 into the body camera.
I'm on Mount Zion.
Take her car. Somebody take her car.
Just tell him I will. Right, well, let's hope they come and out the thing though. Ryan's probably on his way to you.
Let me get some information from the, what's your first name?
Jenny.
J-E,
And
Jennifer?
no,
J-E-N-N-I. What's your middle name?
Lee.
L-E. What's your last name?
Aker. Aker.
Okay. What's your birthday?
10/11/90.
Okay. So what happened today? What exactly happened? I know there's.
We've been having problems. He woke up. He got mad about something we talked about 2 fucking weeks ago. Called me a cunt, a bitch, a whore. Told me that I had to get out and I wouldn't leave because I was trying to find a bra, shoes. He's got our 3-year-old son. And I tried to get our son and he started choking me in the driveway. That he'd fucking kill me. That they weren't my kids anymore.
Okay.
And said that if I tried to come there, if I didn't get out of the driveway, he was gonna shoot me.
Did he have the gun on him?
He's got a 308 assault rifle that he was gonna shoot me with. He's already put it to my head a couple times.
Today?
Not today.
Right.
Prior instances, he tried to chop my head off with a battle axe.
Okay. Did he have the rifle on him?
Yeah.
Did he threaten you? Where did he have it slung?
Yeah, in the back of the truck, in the back seat of that big truck is what he was driving when he decided to pretend like he was gonna leave and then pull back in. So sorry. He put my stuff in the yard and dumped gas.
I didn't see anything on
Indeed.
fire or see any burn marks, so.
He's got a few guns. Some are mine. Which guns he's carrying, but he doesn't not guns.
Okay. Do you think he still has the rifle with him?
He probably left out of the truck because that's my
I
gun.
didn't see it, but what gun would he have on him?
Probably a 350.
Hang on. Okay. So did he do anything besides choke you? Did he hit you?
Just shoved me down the driveway.
He what?
He just was shoving me down the driveway. When I tried to get it, he started punching at it and he fucking grabbed me by the hair of my head and slammed it into the look out of his truck.
Okay.
So I got out.
So he punched you in the head?
Well, he grabbed me by the hair through the window and ripped my head to the door.
Okay, was he in the truck?
No, he was
He was outside? Okay, were you in the truck?
Yeah, I tried to lock myself in, but I didn't have keys.
I'm sorry. So where were you at during this?
I jumped in the little truck and then way and locked the door.
So you were in the little truck?
Yeah.
Okay. And then he pulled, how did you get out of the truck?
Backed away from it and told me that if I didn't get out of the driveway, he was gonna start shooting me. So I just started.
Sorry, hang on 1 second for me. Sorry, what do you say?
Before you cleared, he wanted to know if you wanted to move the weapons.
Yeah. Hey, for a minute, I'm down here. I'll come see if we can secure the weapons. Okay. So you got in a little truck and then he was still yelling at you. He reached in, grabbed your hair, pulled you through, And how did you get out, you said?
Then he just leave me the fuck alone. And he backed up and back across the driveway. So I got out. She was at me. So I started to head down the driveway, grab my shoes.
Okay. At what point did you call 911?
I called while he stole my hair and started yanking it.
Okay, so you were in the truck whenever you started calling?
I called and he told me that he'd opened fire. Please, say who I was. Just fucking play.
Okay. Okay. So you started walking down the driveway and then what did you do?
He just started throwing shoes at me and yelling. Started dumping gas on it.
Okay. Started dumping gas on it. Did he try and light it on fire? Or did he just?
I don't know. I just ran. I just ran.
Okay.
So that I could talk to somebody on the phone on 911.
Where did you go?
And I just
You ran into him
Yeah.
or the, okay. So you walked down here and then, okay.
Yeah, I don't know where he went. I never see our kids again.
And where's she at?
She's at my mother-in-law's in Athens.
Okay. And where's that at? 3010 West Drive?
I think that's what it
Is it right on the corner of West Drive and Athens Road? Okay.
Apartment complex.
You know what apartment it is, number? Or what her name is?
In right up the stairs. It's the very first apartment on the left when you go up the
Go upstairs, okay.
Her name's Mary. She's not the side with me or her son, but obviously she's gonna side with her son.
Okay, hang on,
That's how it goes.
hang on 1 second for me. Stay back.
Trooper Liebrick, is that a true and accurate representation of your first interview with Ms. Akers on the date of the incident?
Yes, it is, ma'am.
And did you have further interactions with her on that date?
I stayed with her for the rest of the incident until I dropped her off at her friend's house.
At any point during the time you were with her, did she indicate that something had happened different than what she had told you initially?
No, ma'am.
And how was her demeanor in the time that you spent with her?
Well, she was obviously distraught during the first interview and interaction. As I spent more time with her, she began to calm down into, I guess, a normal emotional state.
Did you take her back to the Cranberry Lake Road residence?
Yes, I did.
And did you go through that residence with her to look for firearms?
Yes, I did.
What can you tell me about any firearms that were at that residence?
There was a pistol located on the dresser to the bedroom, and then Miss Akers opened up the gun safe and was able to tell me that there were several firearms missing that he took. I believe in her words, them all, stating that he took all of his firearms.
Did she seem knowledgeable about firearms?
At least the ones that she owned. She knew which ones were hers.
And was there ammunition for the firearms that were there?
I do not recall, but I believe so.
Did you have contact with Ryan Swartz on August 22nd, 2022?
No, I did not.
Did you ever see him on that date?
I believe that I passed him while en route to the residence. He was traveling northbound on that road in a smaller pickup truck as I was heading to the scene.
At that point, did you know who that was?
No, I did not.
Did you see any injuries on Miss Akers?
Yes, I did.
And describe those for me.
I know she had an abrasion or scraping along her right hand, as well as her elbow. And it looked like there was dirt on both her butt and her knees, indicating that she was down on the ground. I don't recall all of her injuries, but if I could look at my report to just verify what injuries were there.
Your Honor, may he refresh his memory with the report that he has?
Yes.
This is going to get pretty wild because the defense attorney is
After
going to call
reviewing the
her
report, were there any other injuries?
and she's going to
Yes,
recant
there
all
was,
that.
and I'd like to make a correction. It wasn't her right hand, it was her left hand that was bleeding. And she did have it was a light red mark on the left side of her neck. And then she had bleeding on her knees as well.
I don't believe I have any further questions at this time for the trooper.
Mr. Moore?
Yes, Your Honor, thank you. Trooper, Ms. Akers was not put under oath when you talked to her that day, correct?
Correct, sir.
Did you ever have a chance to speak with Mr. Swartz to get his side of the story?
No, I did not, sir.
Do you know if anyone from the Michigan State Police or the St. Joseph County Sheriff's Department spoke with him before he was arrested?
No, sir, we were unable to locate him on the day of the incident.
Okay,
we
are you?
also had-
All right, thank you, sir. You're familiar with firearms, correct?
Yes, sir.
Okay. Do you know what a difference? Do you know what assault rifle is?
Yes, sir.
Okay. All right. So an assault rifle is one that has typically a higher capacity magazine, and it's a mid-range rifle, correct?
Yes, sir. That's.
All right. Now a 308 is a bolt action hunting rifle, isn't it?
I'm not familiar with that, sir.
Have you ever seen a 308?
I believe I have. I'm familiar with some firearms, not all of them.
Was the 308 that you saw a bolt action hunting rifle?
I did not see it through 308.
No, okay. All right.
Oh, I'm sorry. The one that I had seen previously. I believe so.
Do you believe that it was a bolt action hunting rifle?
I believe so.
Did you ever find any firearms with Mr. Swartz?
Not at the time, sir.
And in reviewing of the video, is it true that Ms. Akers denied that he pointed the gun at her?
Yes, it is, sir.
Did she ever say that day that he had pointed the weapon at her?
Not that day, sir.
Have you re-interviewed Ms. Akers since that day?
No, I have not, sir.
Do you know if anyone from law enforcement, as far as the Michigan State Police or the Sheriff's Department, has?
Nobody has interviewed her.
Okay. All right. Thank you, Your Honor. I have no further questions.
Thank you, Trooper. Now, why don't you come back in the courtroom? All right, Deborah, who's your next witness?
Your Honor, the people will call Jenny Akers.
Oh, good Lord.
I'm right up here. It should be-
Jenny is adverse. Keep in mind. She's not cooperating with Deborah. She was hiding.
Good afternoon. I'd
She
like
was
to
not
request that you
cooperating.
raise your right hand.
And that's why this is an
You swear or
absolute
affirm
error
that
to
any
prosecute.
testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Thank you.
Here we go.
Have a seat. We heard you state and spell your name, so I won't make you do that again. What would you state your name?
Jenny Akers.
Ms. Davis?
Thank you. Ms. Akers, on August 22nd, 2022, were you residing at 11672 Cranberry Lake Road in Marcellus?
Yes.
And who lived there with you at the time?
Myself, Ryan, and our 2 children.
And when you say Ryan, is that Ryan Swartz?
Yes.
And is Ryan in the courtroom today?
Yes.
And can you describe what he's wearing and point him out for the record, please?
He's wearing a jail outfit, cuffs, and combed hair.
May the record reflect that she has identified the defendant.
It may.
Ms. Akers, do you have children together with Mr. Swartz?
Yes, 2.
And did you call 911 on August 22nd, 2022?
Yes.
Did you call more than once?
I don't recall. I thought I only called once and then they called me back because we don't get service there.
While you were on the phone with 911, were you and Ryan having an argument?
No, while I was on the phone with them, I was already down the driveway.
And was Ryan within hearing distance of the 911 operator?
No, I was at the bottom of the driveway headed to leave the house and he was standing up on the porch.
And what was he
or
saying?
The porch vicinity. I don't know, ma'am. I don't recall. I was listening to the operator on the phone.
Where was your child?
Inside, but our daughter was at my mother-in-law's house.
Let's nail this down. What's your daughter's name?
Cadence.
Cadence.
Kaydence.
I wasn't even close. And how old is she?
She just turned 12, December 14th.
And she was in Athens?
Yep.
Yes.
And your son?
George.
How old is he?
He's 3.
And he was in the house?
Yes, he was inside.
Was anybody else in the house?
No, sir. We stepped outside because we don't like to argue in front of our children as much as possible.
Was he awake?
I believe he was sleeping at the time, but I'm not 100%. I do not recall.
So he was in his room?
Correct.
All right, Deborah, go ahead.
Why did you call 911 that date?
I called because Ryan said that he's gonna take the kids and I went and see him again and I got scared and I wanted to get the children into my physical custody.
At some point, did you leave that residence on foot that day?
Yes, yes.
And where did you go?
I started to walk towards town, so to diffuse the situation.
Did you try to use the vehicle first?
No, no, none of those vehicles are mine, so. My
have you ever-
mother-in-law actually had my car, so she was supposed to, I was trying to get a hold of her to bring my car to me. None of those vehicles are mine.
Have you
my
ever-
mother-in-law-
Have you ever driven the vehicles that were in the driveway?
On occasion.
Okay. And how far from town is it if you're walking?
I would assume, I honestly couldn't tell you, maybe 6 miles, 5 miles, maybe. I'm not 100%. Probably
Do you
the same as it was driving, I think.
Do you typically walk to town?
Yeah, I have a couple times. My daughter and I, we like to get out and about, walk. We pick up pop bottles. We pick up flowers.
And on the 22nd, on your walk, did you come across a St. Joseph County Sheriff's Department deputy?
Not cooperative with your theory.
And did you stay with that deputy until Trooper Andrew Liebrecht came to talk to you?
Yes.
You saw the body cam of Trooper Liebrecht that was just played, correct?
Yes, I did.
Was that you in the video?
Yes, it was.
And were you describing to the trooper incidents that had occurred with Ryan Swartz?
I was describing what I had decided to make up in my head, thinking that whatever I told him would get my children into my custody.
We knew it was coming.
Your Honor, I would ask that the court advise the witness of her Fifth Amendment rights based on her testimony that's coming.
All right, there are some issues that are coming up. One is you're under oath and anything
Perjury.
you say here is subject to perjury. Second, what you're talking about now is filing a false police report regarding felony, which is a felony.
Yep.
And so you would have a Fifth Amendment right not to incriminate yourself. And
Well, you just did.
they're not at this point granting you a false police report. Do you understand?
Yes, sir.
All right, if you wish to take the Fifth Amendment, not answer questions about that, you can do that. However, if you wish to give this version of facts, I guess you all could also can do that. You're not being given immunity, so I don't have to appoint counsel for you. But there is a concern that these statements, if they are in fact false, could be the basis for criminal charges. Do you understand?
Yes, sir.
All right. I lost Ms. Davis momentarily. All right.
Sorry, Your Honor. My Zoom froze. It ended with that we were not granting immunity at this time.
And I advised her that she can take the Fifth Amendment if she feels this would be implicating her in a criminal charge. And she stated that she understood. And I will not be offended if you do ask her. The Fifth Amendment is your right under the United States Constitution to not provide testimony against yourself or evidence that would intend to incriminate you. And for most purposes, you can't be compelled as a witness to give incriminating evidence against yourself. All right. Let's go to our next question and see where this takes us.
Jenny, do you or Ryan have a 308 gun?
I believe I do, yes.
And did you have it on August 22nd, 2022?
It was, I don't recall. I didn't have anything in my possession. But was it in the house? Probably in the house, yeah.
Do you remember going through the gun safe with the trooper after you had that initial conversation with the trooper?
I recall the trooper asking me if I could go in and check, and I told him, yes, I could run in and check. And then I ran in and checked, yes, and they come up behind me Yes, I recall that.
And
Yes.
isn't it true that there were guns that were missing out of the gun safe?
No, I don't know. They were there. They seen them there.
So you don't recall?
It wasn't in the safe. You're correct. I'm sorry. It wasn't in the safe. There was one on top of the safe and one on the dresser. So no, I guess it wouldn't have been in the safe.
And was it
So
your
initially looking in the safe, yes, there would have appeared to have been missing, but located it on top of the safe and then on the dresser.
You don't recall telling the trooper that Ryan's guns were missing out of the gun safe?
No.
You don't recall it, or you didn't say that?
It was, like I said, it wasn't missing, it was on the dresser.
What gun are we talking about?
I believe it was a 357.
Is that a handgun?
Yes, ma'am.
But you and Ryan have matching handguns, correct?
No.
You don't recall telling the trooper about the matching handguns that you and Ryan both have?
Those are not, those were in the safe, yes.
But they were not in the safe.
Matching, the handguns that we have matching are not 357s. They were Colt 45s.
Okay. And so was Ryan's Colt 45 in the gun safe when you went with the trooper?
I don't recall, ma'am.
No further questions at this time.
Oh, good Lord. Debbie did a great
You
job.
mentioned a 308 bolt action rifle in his car. Do you know anything about a 308 bolt action rifle?
It was in the safe. It was never in his car, Your Honor. Like I said, I did lie. I don't really recall a whole lot from that day. I will be honest. I am struggling.
I don't want to, I'll let them ask you questions.
Okay.
So the 308 bolt action was in the safe?
I don't recall, but I believe so. Yes, there was no weapons in the vehicle.
How do you know that?
Because the officer went through and checked and came back and stated that there was no weapons in any of the vehicles.
All right. But Ryan and one vehicle were in fact gone. Isn't that true?
When I came back with the officer, yes, Ryan wasn't there.
And the vehicle was gone?
Yes.
Which was what?
That was his dad's truck.
What is it?
I don't know, it's a little truck with 4 doors.
All right, Mr. Moore, do you have questions you wish to ask?
Yes, thank you. Ms. Akers, taking you back to August 22nd of this year, did Ryan Swartz strangle you in any way?
No, I did not.
Did he put his arm or his hands or any type of device at all around your neck and try to choke you?
No, I did not.
Did he threaten you with any type of firearm, rifle, pistol, anything?
No, I did not.
Did he point a rifle or a pistol at you that day?
No, I did not.
Did he place you in fear at all with any type of firearm, a pistol, a rifle, anything?
No, I did not.
Now, Mr. Swartz wanted to leave you in the home, correct?
He just asked for me to leave, yes, because that is his home.
But then he left,
Yes, he left.
and he left with your child.
Yes.
Did that make you very upset?
It's, yes, that's, the purpose of my call to the officer was to see if I couldn't get the children into my custody, but he said since the children were both ours, that was not an option.
Jeez. Just admitted to a full felony on the stand right there.
Did he, on that day, was there any harmful or offensive contact or touching on his behalf towards you?
No, sir.
She is.
Did he threaten you with an immediate contact, offensive contact, offensive or harmful contact or touching? Did he put you in fear of that?
No.
Now, the trooper said that he saw abrasions on your hand or hands and elbow and maybe some dirt on your bottom and your knees. What do you have to say about that?
Howdy.
When Ryan went to leave I attempted to jump into the back of his truck and almost made it, but fell, so it's all caused to myself by myself.
Now, you're not saying that he was trying to run you over, correct?
No, he was not. I ran down behind this vehicle and tried to jump into the back of his truck so that he couldn't leave.
Now, the trooper testified that he saw a red mark on your neck. I mean, what do you have to say about that?
I would say that's because when I'm nervous and I rub my neck like this.
So you think that you gave yourself that mark?
I didn't recall having any marks on my neck. He's the only one that would have seen that. I don't recall having any marks on my neck.
But it's your testimony today that you get flushed and you, as in like maybe a nervous tick, you rub your neck.
Yes.
Your Honor, I have no further questions.
I've got a couple. Debbie, do you have any?
Just a few. Jenny, would it refresh your memory about what was said about the guns in the gun safe and what was in the gun safe if you were to watch the body cam footage of going through it?
I guess you could try. Like I said, the officers I told them I could go inside my home. They weren't supposed to follow me into my home. I told them I could step inside and check. So I didn't know that they were going to be following me into the home.
When there's guns and people, officers follow you into the home. They're not gonna stand there and let you go in and open a gun safe without them being nearby.
Right.
But that's a safety issue, but go ahead.
Thank you, Your Honor. For the record, this will be starting the video at 58:51 into the body cam video. Jenny, do you see the still shot?
Yes, I do.
And who is that on the left-hand side and where is that?
That looks like myself in our bedroom.
Okay.
I have bullets, but there's 145.
You didn't grab that at all?
No,
Okay.
that one's mine. We have matching, so I can't tell which of
Are any of these loaded?
That one should be. Hit ball. He's got a ball. This is empty. He took everything.
You took all the guns?
He's got every gun. There's only one in here.
What, two? Is that small one? Is
Yeah,
a shotgun?
that's mine. That one's mine, and then that one over there is mine. So he's got all of them.
Really? Yeah, that's not going better.
Yep. He's got them all.
Okay. Before he left?
And they were here before he left.
How many does he have?
I'd say he's got a 357, 245.
257, hang on. 357 Magnum and 245.
He's got
You know,
the a 1911 45 ACP Springfield.
long gun, short
The-
gun,
That's
pistol.
yeah, the automatic pistol. And then the other one's gonna look just like this one right here. It's gonna be a 45 Colt. Between mine and his name. They're either,
These pistols.
this one's in my name, that's 38 special in my name. That 45
All right,
Colt.
Your Honor, at this point, I don't see the
We got
relevance.
matching, so
I don't see the relevance of
that's
this,
the
Your
right
Honor.
one. That's his. And then the 357 is in his name. The
She's
308 is
impeaching
in
her
his
own
name.
witness and.
I thought she was trying to refresh her memory.
Recollection.
Yes.
Yeah,
and,
you should have objected
so
long ago.
This is refreshing her memory, so the objection at this point is overruled. We'll see where we go. Is there anything further from this, Deborah?
Just a little bit.
And the 45 Colt, that's a revolver.
Yeah,
Okay, what other gun does he have?
I
I
think
got
that
three.
should add him up. Well, if you've got the 308, that's,
So he has
AR.
4.
yeah, the 308 is an AR.
What kind?
It's a bolt action. That's all I know about it. It's actually supposed to be.
Do you know make and model or?
I don't. He was just teaching me and stuff. Yeah, he emptied it out.
Okay. Just leave it there.
May I ask you, would you have a problem giving these up for safekeeping while you guys are fighting? Figure out what's going on?
Rather not.
Ms. Akers, does that refresh your memory about what you said to the officers that day regarding the guns?
Yes,
And so you referred to the 308 as an AR assault rifle, correct?
yes, but that's, I believe, inaccurate. I'm not 100%.
Okay.
I don't think a bolt action is an AR. I'm not really sure, ma'am.
You opened the gun safe yourself, right?
That's correct.
Who else has the code to open that safe?
I'm not sure, ma'am. I know the code because my father-in-law had told me it before he passed, so I could get into it for him.
Isn't it
As
true
far
that
as I know,
Ryan
as far as
has
I
the
know,
code?
I'm the only one that knows it.
So it's your testimony that Ryan Swartz doesn't know the code to that safe?
I don't believe so. He's always had to ask.
And you placed that pink gun in the safe that day, correct?
Yes, ma'am. It's our daughter's. So she has, I get it out for her and she puts it on top of the safe when she's done target shooting her target if she wants to. So, and I had forgot to put it away from the last time she had used it.
Okay. No further questions at this time.
I'm trying to get straight in my mind, at what point you tried to jump in the truck. Your testimony was that you walked down to the bottom of the hill, called 911.
Yes.
He was up on the porch.
Yep.
And then you started to walk away. In my estimate, it's about 12 to 14 miles to town from there. But you were gonna walk all the way to town, or did you have a destination in mind?
Like I said, I didn't really have a destination. We were trying to just disperse to diffuse the situation.
So at what point did you attempt to, so you're walking away to diffuse the situation, but then at some point you tried to
I
jump in?
came back, yes, I came back up the driveway to ask for, I said, can I at least get my shoes? And, you know, he threw them out into the driveway. He didn't actually throw them, like he wasn't throwing them at me. He was throwing them to me because I came up and asked for shoes. Then he got into his vehicle and headed down the driveway with, well, he obviously loaded up our son and to defuse the situation and started to leave and hollered out that I would never see the kids again. So it scared me and I attempted to jump into the back of the truck and fell.
What was he mad about in the first place?
Well, one is because we struggle with the fact that I started using drugs. And two was because he was upset because I had went and started talking with his brother.
That's what started the whole argument?
Well, yes, but the fact that I was under the influence of amphetamines and he, didn't want me there because of that.
My God.
Anything further? No, not from you.
Just briefly, Jenny, why did you call 911?
Asked and answered.
I would like
Because
some clarification.
I'll allow to answer.
Because he told me to leave and I wanted to take the child with me and he said, no, I could leave on my own because I needed to go and get myself right and I needed to get some mental help and some counseling and whatever, and that the kid, it was not, in the kid's best interest to go with me. So we fought over that. I didn't want to leave because I wanted obviously my son to go with me. And he wanted him to stay there because he felt that was in our child's best interest for him to stay there with him since the state that I am been in.
Do you remember what you said to the 911 operator?
No, I don't.
Would it refresh your memory if I played the tape
Here
for
it
you?
comes.
Oh dear. Say no.
Refresh my memory.
Don't make this
Like
painful.
I said, I was under the influence of drugs and I don't really recall what I said.
Your Honor, I'd ask to be permitted to play the audio recording of the 911 tape that was obtained by Trooper Liebrecht and provided to the prosecutor's office.
Your Honor,
All
I
right,
guess I would
we've gotta know what it's for. If it's for substantive evidence as an excited utterance, which clearly it would be even more of an excited utterance than the first one, you need to lay a foundation for it. If it's simply to refresh your recollection, it's not substantive evidence, but I don't think she's gonna change her testimony. I think if you're gonna get it in, it needs to be substantive evidence under MRE 8032. Mr. Moore?
Yes, Your Honor, I objected it and didn't think you stated everything in advance.
Well, I already know what
And
your
Your
ruling
Honor,
is.
I would state that I reviewed this. The defense has had this tape since the beginning. It is certainly an excited utterance while she's under the stress of the situation that is happening. It's present sense impression for kind of narrating what is going on during the call. So I believe that it fits under the exceptions. I can certainly get somebody from Central Dispatch to authenticate it. If necessary for this preliminary exam purpose, I would ask that it come in based on the reasons that I've given so far.
Then, Your Honor, I would object under MRE 403 because at this point it's duplicative. It's already been testified to by the trooper. We've already heard it, and this is just a needless waste of time.
Well, I disagree. It might be duplicative, but it's also indicative of the proof.
Duplicative, but indicative. No,
And
she's lying about it.
It's on
It's
here
separate.
in addition to what she told the trooper. If the
Well,
affidavit is correct, he
poor
is
Attorney
also
Moore there. He was
on
dealt a bad
the
hand.
911 tape in the background. I'm interested in hearing it, but my fear is we don't have a proper foundation for it.
Oh, good Lord. She's going to have to.
So it would be subject to foundational evidence from a 911 witness as to what it is. Subject to that, we may need further testimony. So it can be used to refresh your recollection, and if you lay a proper foundation, it can be used substantively.
Your Honor,
Invite which your staff to get somebody from 911 to zoom in here.
yes. Give me
Yeah,
one moment. I sent a message, but I don't think that they
Custodian of
saw
records.
it. So give me one moment.
Well,
This is frustrating. This is law, people.
are we going to get just someone or the actual
She's lying through her
operator that
teeth.
night, records keeper, all those things?
Well, probably the records keeper will probably gonna seek the 911 director. I don't know who she's got.
Yeah, you would need the actual dispatch and the custodian of records.
Meanwhile, this woman.
And is it possible to have a breakout room real quick with Ms. Davis, if she would like to?
Yes, Deborah, I'm gonna put you and David in a breakout room. We will wait here.
Sure. And we're getting central dispatch. They keep her the records.
All right.
Now, this is just a misdemeanor.
Annie, do you need to use the
Felony
restroom?
charges. This is there must be because there's no jury, right? Must be misdemeanor.
There's no jury. It's preliminary hearing.
Oh, it's a prelim. Okay.
It's a prelim, and that's why he says duplicative. But
We'll talk about that in a minute.
we're always worried about evidence being cumulative, but not in front of a judge on a prelim or a bench trial.
Right.
Yeah, you know, that doesn't think. But this woman under oath on the stand in front of a judge testifies to drug use, felony drug use, and felony obstruction of justice and filing a false police report to cover for a guy that strangled her.
Yeah. Yeah, this is crazy.
That's what I think we're facing here. Well, I don't know. I wasn't there. But, cover for a guy that she said strangled her.
Right.
And I've seen this a bunch of times. I was a prosecutor many, many moons ago, and I've seen this. This has come up. These DV things come up on my channel, and I say things, and people get all cranky with me. I'm like, I know how this is going. They recant every time.
Right.
And no, you're not mistaken. It is hot in here.
It's getting hot in here.
Oh.
It's so hot.
It's just hot.
So,
this got serious, man.
Yeah, this.
Deborah's in a mess trying to lay a foundation with this. I don't know. I don't know. The defense attorney I think is doing a really good job. I think Deborah's doing a really good job.
Is it possible for me to speak with my client privately? There may be a resolution.
Why aren't they in the courtroom? Are they still on
bailiff and the trooper to escort him to the
COVID protocols?
and wait outside.
The judge, the witness, and the defendant are all in the courtroom. Why?
I don't know why that's the case.
I mean, sometimes it's nice when the defendant isn't there because they just they keep talking in your ear and you can't listen to anything being
okay,
said.
So I'm going to do this. I'll do a couple super chats that were here, but they were like too complicated.
All right, just stop. I'm sorry.
Oh.
She's fine.
Yeah, suborning perjury, wouldn't you say?
Correct. Yeah, absolutely. You would get in trouble.
The thing is, all of her lies
All right.
were in response to Deborah's questions. He wasn't.
Button that says join.
Right. He's not the one suborning any perjury.
Right. I mean, he knows she's going to lie and he stays out of the way, but he isn't like directing her to do it and putting her on the stand knowing it's false.
We'll just wait.
Correct.
We're good at that.
Yeah.
I mean, it's the fact finder, really. I don't.
Right.
I mean, they're supposed to if it's used for purposes, if it's not used for substantive purposes, then no, they can't. They shouldn't be able to. It shouldn't reach the threshold of beyond a reasonable doubt.
Well, if it gets in, the finder of fact gives it whatever weight they think it should get. Yeah.
But
I mean,
yeah,
these are
I
really
think-
complicated questions.
Right, but I think human nature would be, yes, if you heard the recording of the 911 call and then saw her saying,
Yeah.
no, I scratched my neck and that's how I got this. You'd be like, yeah, I don't believe that. Let's see, what is this? I wonder what kind of. Yeah, we have, look, victims and witness, what do they call it? Victims witness advocates. And there's a lot to be said about them. They are, I don't know. Maybe I shouldn't comment too much on them. But look, there are times when domestic violence claims are, if they're not true, they're exaggerated or things like that. Not all victims are, I've encountered it. I've had them say, look, I exaggerated. I just wanted him, whatever. And so it's complicated. It's not as clean and pure as, oh yeah, she's just simply straightforward lying now, and everything then was true. It's been my experience that there are times when some of these claims are exaggerated.
Yep.
And so then you get, then that puts them in the awkward position of, well, you signed you made a voluntary statement. It's signed under penalty of perjury. If you change it now, we're going to come get you. And so it's tough. They're put in this, and a lot of them are abused, but then they're like, they go there and they're like, if you change your comment,
Judges, I believe we have a resolution for the entire case.
We're going to prosecute you. So it's, I don't know. There's no good answers.
I did not see this coming.
All right, let's go back on the record. In the meantime, the defendant had an opportunity to discuss things privately with his lawyer. Thank you for the breakout room.
That's what we're all afraid of, Chip.
Proceeding, we were doing things today, but because of the holiday and vacation schedule and other things, we ended up doing a hybrid presentation. Mr. Moore, what's our status here?
Yes, Your Honor. I had a chance to speak with Ms. Davis from the prosecutor's office. She made the following offer: she will dismiss the charges against Mr. Swartz, if he pleads to 2 counts of domestic violence. He will have 769-4A treatment for both of these counts, and the balance of the charges will be dismissed.
The prosecution would have no objection to 769-4A.
Correct.
Well, I guess we can. Miss Akers, you can go have a seat on the bench there.
They're doing it. This is good for everybody to see because you're really following it and you see how dirty this stuff gets, like how complex this is.
Right.
He's only talking about having him plead to something because Deborah's doing a good job, and Deborah's only agreeing to plead to something because he's doing a good job. That's what's going on here.
There's risk for both parties here at this point.
There's risk for both parties. They're both good. She doesn't have her main witness won't cooperate with her. You just saw it. But he's sitting there going, you know what? Both of you are going to lose your kids. And you're going to end up going away for filing a false report while he's away for DV, and these kids are going into custody. Think about that. Those are the conversations that are happening behind the scenes. I'm guessing. I don't know, but that's what I'm guessing.
Yeah. Bubba Smith, yes, the judge can object. The judge is not a party to these negotiations, so he is not bound by them.
Yeah. That might be true.
We'll see. He said he objected to the whatever that.
Yeah. Yes.
Type of.
The judge doesn't have to accept this deal. He can say, I'm not taking this plea, but all you needed to hear in this case is he tells the witness to go sit down, which means he's accepting this plea. And the code provisions, which I'm not familiar with, imply a certain deal, and he knows exactly what it is already. Because they said, oh, you get 761 treatment or whatever. I don't know what that is, but they do. Judge knows exactly what how that's going to be sentenced as he hears it, and this thing is done.
Right. Here, I know for drug cases, like a first offense felony drug case, we have 3363 treatment, which refers to the line of code, whatever in the statute, and that allows someone to drop their
Swartz,
drug, whatever their drug condition
charged
down.
with assault with intent to commit great bodily harm, assault with a dangerous weapon, and domestic violence. The prosecutor has agreed to dismiss the assault with intent to commit great bodily harm, turn it into a domestic assault. Assault with a dangerous weapon would be dismissed, and the second count of domestic violence would be a misdemeanor. So there would be a plea to 2 counts of domestic assault. Those are misdemeanors punishable by up to 93 days in jail and a fine of up to $500. Also, this goes without saying that they would not charge you with possession of a firearm during the commission of a felony, which carries a mandatory minimum 2-year prison sentence. Do you understand?
Yes, sir.
Did you have a chance to consult with your attorney regarding that?
Yes, sir.
And are you going to plead guilty to those 2 charges?
Yes, sir.
All right, let me ask you a couple questions. You sat through this testimony, same as the rest of us, but did anyone promise you anything other than this very generous plea agreement to get you to plead to this charge?
Yes, sir.
Or threaten you?
Yes, sir.
Do you understand that if you do plead to this charge, you will be giving up your right to have a trial? This preliminary examination was to determine whether there's probable cause to believe there's a crime. At a trial, you'd be entitled to be proven guilty beyond a reasonable doubt. You're giving that up. You understand?
He has a prior too, I
At a
think.
trial, you'd have the right to be represented by an attorney. Mr. Moore is here. You could also have had an attorney appointed if you had requested.
Tell him to hold still in his
Trial,
chair.
you have a right to take the witness stand yourself and testify and tell your side of the
Give him a
story.
swivel chair.
But you don't have to because you have a right not to testify.
He'll quash the
You do not
warrant
wish to testify.
because she came in and this all got resolved. He's not going to whack her on top of it. Not now.
And
I don't know, but that's what I'm guessing.
I said this already. You have a right to have any of the witnesses for or against you subpoenaed. And as I mentioned, you have the right to be proven guilty beyond a reasonable doubt if they're able to do that. To understand all that.
Yes, sir.
All right, we're asking about 2 separate incidents where you assaulted your girlfriend, children, mother. On this day, August 22nd, were you guys together at the Cranberry Lake address?
Sir.
And did you and she get into an argument?
Yes, sir.
All right, did you put your hands on her?
I pushed her, yes, once, and she's right. I did reach through the truck, at the window of the truck, and pull her hair once.
All right, so you pushed her. Did she fall down?
No.
Where did that pushing take place?
Mid driveway, right by the gate.
And then you pulled her hair and yanked on it when she was in the truck.
Yes, sir.
Which truck was she in?
She was in the little truck that I left in.
All right, which is what?
Did the attorney just stipulate to a factual basis?
2004
So he
GMC
stops talking.
All right. And so that belongs to your father?
It belongs to me now. I bought that from the estate.
All right, but she was gonna leave in that truck and you didn't want her to?
She got in the truck because she was, because I was yelling and telling her to leave, get out of the driveway.
How long have you lived together there?
We've lived together there since 2018. My dad recently passed 2021, day after Thanksgiving.
You and I discussed.
Or give him
that. You
a
don't have
swivel
fair
chair.
Understanding of landlord tenant.
We have swivel chairs here
She's
in
not a
Nevada.
piece of luggage that
I've
you just
heard.
throw out and say leave. She's a lawful occupant and tenant of your house. And you also don't have a very good understanding of child custody law. As the two of you are not married, she is presumed to have paramount custody of the children. So you're treating them like a pet, and you're treating her like a piece of furniture that you could put out of the house when it was time to, when you felt like it was time to. So I'll accept your plea. Ms. Davis, does this encompass anything to do with the allegations that he tampered with a pending witness or obstructed justice?
No, that was not part of it, and we haven't decided on anything because nothing has been sent up yet. So I haven't seen the evidence.
This encompasses only the actions of August 22nd.
Correct.
Is that your understanding, Mr. Moore?
Yes.
All right. All right. Are you satisfied with the factual basis, Deborah?
It's sufficient. Thank you.
Are you, Mr. Moore?
Ooh,
Yes.
she's still pissed.
Yeah.
Now, what
Don't need a body language expert to do that.
what your lawyer said is there's a section under the domestic violence law which would allow you to be placed on a probation, and if you successfully completed the
That's the code provision they were citing.
the charge would be taken off your record.
Okay.
And I can only do that if the prosecutor consents. You've been in jail now for 19 days. And
He
then
does
you
have
get
to earn
some
it.
days at the
He'll screw it
front
up.
end. So let's see how long you're in jail.
20 days, Your Honor.
You got arrested on the 26th of October, and you posted bond on November 4th. So that's 5 days in October. No, the bond was posted on the 27th, so you just did 1 day. So you're right, you've done 20 days. I believe everything that Jenny Akers said to the trooper at the scene.
Yep.
I believe everything you said right then
It
and
wasn't
there
admitted to
was the
substantive
truth. And it
evidence,
most
though, was it?
generally
It was
is
just
what is said
refreshed
closest
recollection.
in
So
time to the
I want to hear what he
facts.
says
And
about
I
it.
regret the fact that I believe you just committed perjury here in open court.
Yep.
But I wasn't there. But I believe you. And I believe everything you said on August 22nd. I don't want to defer your sentence, and I don't want you on probation. I think you're manipulative and potentially dangerous. And you can all go home and look up gaslighting. He's telling you you're crazy and you need mental health treatment and you need to get your act together. Making all this somehow your fault. And then you hide from service, don't show up in court when you are actually served, and come here to court today and give what I believe to be false testimony, which puts the prosecutor in a very difficult position in attempting to prove this case beyond a reasonable doubt. So they took what they could get, which is 2 counts of 93 days in jail, credit 20. I don't want you on probation. I don't want this to be deferred. I want it to go on your record. So that's my sentence. I didn't give anybody opportunity for elocution, but it isn't going to change my mind. All right, now you'll get good time with that, 93 days minus good time. He has 20 days, so that's 73 days minus about another 30, meaning he has about another 40 days to do, unless I charge him with something else. All right, Mr. Swartz, you can go with the court officer.
Thank you, Your Honor.
Don't leave yet. Ms. Swartz or Ms. Akers, I want you to come back up here and have a seat. Right
Oh
over
boy.
here at the defense.
What's he gonna say?
This can't be good.
Lecture her? What's he gonna say?
Yeah, he's just going to chew her out nicely. Nicer than she deserves, frankly.
This is regarding the.
Well, they're not gonna
contempt
remand her
of
for perjury.
Jane Akers. She failed to appear on a couple of occasions. On the
Wow.
first day,
They have an outstanding warrant, too.
She knew she was supposed to be here, but did not come, but she had not been served. She was supposed to be here on December 20th, and she was served, but did not appear. She was watching the live feed and called into the court, said she didn't like what was being said, and she didn't like the way she was treated. But she wasn't here, so I issued a bench warrant. So I'm going to recall the bench warrant.
I knew he would.
Well, I mean, it's just a material witness warrant, right?
Before you were born, I used to be the county prosecutor for 23 years and handled hundreds of domestic violence cases. For a number of years, I was on the domestic violence, TASC, it was called Domestic Violence Assault Shelter Board of Directors, for probably 10 or 12 years. A lot of training about prosecuting and understanding domestic violence. And then I've been a judge for 20 years, and I've seen a few hundred more domestic violence cases. When I started in 1980, this pains me to even say this, there was no right to make an arrest. Here's a history lesson for you on domestic. There was no such thing as domestic violence. It was called assault and battery. And a police officer couldn't make an arrest for a misdemeanor unless it was committed in their presence. So no one ever got arrested for domestic assault because it didn't happen with a police officer. And there was no place to go. There was no assault shelter. They would sometimes, the good cops would take people to their mom's house or get them out of the situation, but they couldn't make an arrest. And before my predecessor, Bob Karras, took over, they had a policy that they had a 10-day waiting period. They had the women wait 10 days and made them come in and sign the complaint. So nobody ever got prosecuted for beating their wife. There was no domestic violence. There was no right to arrest for a misdemeanor not committed in your presence. And they had this absurd policy where they made the women wait 10 days and then sign the warrant. Imagine how that went. Nobody ever followed through. When my predecessor, Bob Karras, took over in 1981, he changed everything. And we had a policy in the early 80s that we didn't drop the charges. If the woman came in and asked us to drop the charges, we wouldn't do it. we would prosecute anyway, whether they agreed to or not. And I can't tell you how many times the women came up to me and said, because ultimately they would cave and plead. Then there was a lot of talk about proving the case without the complainant. The rules changed. They allowed the rest without being committed in your presence in a domestic violence situation. We had support services. We had this deferral law. I started a domestic violence treatment program when I was prosecutor, started the anger management program when I was prosecutor. Those things didn't exist. But what is the same is frightened, intimidated, beaten down women who accept that state and come to the aid of their abuser. So you were in contempt for not appearing, but I'm not going to further punish you for failing to appear. You were frightened. You didn't like the way you were treated at the prosecutor's office from what you left on the message. I don't know anything about that. But to put you in jail for being afraid to come here further punishes you. And I believe you got choked. I believe you got threatened with a gun. I believe he threatened to take your children. And I believe everything you told the officers that day was the truth. So I'm recalling the bench warrant, and I'm not going to pursue any further contempt. The prosecutor may choose to either charge you with filing a false police report or perjury. That's probably unlikely, but there's still the unresolved issue of these phone calls that he made in direct contradiction of my order to him. I don't know what they're going to do with that. You didn't want to hear the 911 tape because it was, I haven't heard it. I wanted to hear it because you would have known it was the truth. All right, the bench warrant for Jenny Akers is recalled. I'm not pursuing any further contempt. The other criminal charges regarding Mr. Swartz have been dismissed, and he's going to do the balance of 93 days minus good time. Ms. Akers, I'm not sure what is going to happen with your child custody and all those issues, whether you're going to live happily ever after or each go your different direction. Methamphetamine is not the answer to your question. All right, you're free to go.
Thank you, sir. Thank you, Your Honor.
Thank you.
Judge.
All right, that completes our record and it completes our day.
Wow.
How about that?
That was a heater. I'm glad you came by for it. At the end, so that I didn't anticipate. I mean, it doesn't surprise me. I just didn't think it would happen mid-hearing. So they come to a deal. He pleads to it. That made him eligible for a deferred sentence and a parole, whatever, not to be on his record. But then he sentences immediately. Tell me if you read it the same way I did. He said, "No, I want this on your record, so I'm not doing that. I'm going to sentence it to you, and it's a conviction."
Correct. Yeah. No, he's got
93 days credit for time served.
Right. He's got what, 40 more days? He said, and then. I don't know.
Anybody, by the way, I think both the judge and both attorneys were excellent. I thought the defense attorney was excellent. Just because you don't like his client and what he was doing what you would do for your client.
Right.
and that created him knowing what he's doing, and Deborah knowing what she's doing, created the risk for each other, like we discussed. And then something had to be done.
Right. People don't like seeing how the sausage is made, but this happens all the time. Usually in cases like this, so I tell them, I'm like, if because I get the victims that'll come to me and say, "Oh yeah, I lied." And usually, I talk to them one-on-one. When that happens, I usually send my client out. I was like, "Go out. I want to talk to her alone." So I usually tell them, "Look, I'll be prepared for whatever happens, but if it's not true, don't do this. You're gonna get in more trouble." Is usually what I tell them. And I just said, "Look, if you don't think he deserves something, to tell that to the prosecutor. Don't tell it to me, because I can't tell you not to go. I won't tell you not to go to court, because they come to me and ask me, well, should I stay? If I don't go, right? Does it get dismissed? I'm like, look, I can't tell you not to go. Yes, that's true, but if you've been served with a subpoena, you have to go. I can't tell you not to go, and I won't tell you not to go. It's not worth
Right.
It's not worth my bar license for them, for this guy. Not
Absolutely.
To have a TV, but usually I tell them that, because then we usually don't get to this point. Usually it's been my experience, at least here, is if the and sometimes, like I say, the truth is sometimes in the middle. They're like, look, it was I exaggerated,
she may have exaggerated.
I fell down and I said this, or that my ankle was hurting me, or whatever. None of that's true, and blah blah blah. But it's so usually, though, I want to tell them, it's like, you go tell that to the prosecutor. We'll set this for trial, and you go tell them that, and then usually the prosecutor comes and say, she's hemming and hawing, and I said, look, yeah, I spoke to her already, and so usually we'll get they'll do the domestic violence counseling with a dismissal at the end, or with a disturbing the peace. Usually there's some kind of compromise we make, because there's risk for both of us in that situation. But usually, I think it's probably interesting for a lot of people to see kind of how the sausage is made. This is not really a clean business, as it were. And it just, and this, what he was saying is true, like in the 80s, whatever. But really, ever since OJ, 94, 95, whenever OJ was, and all his domestic violences against Nicole, and now, the pendulum has swung the other way. Really, we have, there's so many, like at least here, and I'm sure it's the same in probably most other jurisdictions. If there's any allegation of two people that have a domestic relationship, if there's any physical contact during a dispute, it's a mandatory arrest. Like they have no discretion, and so they have to arrest someone. And it gets. I had one. I don't know if you got time, but a brief story. Guy was here. He this little Hispanic couple. They didn't speak English. He drove an ice cream truck. So it was always nice to visit him when he would come to visit me. But he ate something. She was cooking. He went to go eat it while it was on the the pan there, and she was like, "No, don't eat that." And I can't remember what he did. Like he had the spoon there, and I can't remember if he swatted her hand or kind of stiff armed her while he was eating. They lived in a tiny apartment. Neighbors call the cops that there was fighting. Cops knock on the door, separate them, and she's like in my office crying because they arrest him, they take him away. He's like, he didn't do anything to me. I was like, did you tell them that he touched you? I was like, well, yeah, that he pushed my hand away when I tried to get the spoon out of his hand. I was like, that's enough. That's domestic violence. It's, we always think it's, this is, a punch in the face. This is, pushing her down, strangling or whatever, but honestly, if there's a dispute and he, no, I'm eating here. I want to eat this. And she's like, no, it's not ready yet. You're going to get worms, whatever. That's domestic violence. And so and then prosecutors get resources now. Like I say, we don't ignore it. And now we've committed so many resources that, they get the more domestic violence cases they have, the more money and the more resources they get. So it's like, it almost creates a perverse incentive. And I don't know. Some sort of, if I tell you, Mike, you bring me as many domestic violence cases you get, I'm going to give you more money. What are you going to do?
Right.
You're going to bring me more domestic violence cases. Someone's, trying to stiff or take someone's spoon out of their hand because the food's not ready is the same as if he had punched her in the face. And it's,
Mhm.
I don't know. It's the same consequence. And so I don't know. It's not always.
We're always going back and forth, and this is why you have courts, because you have to do these factual determinations. But I'm sure some people are disappointed looking at this, saying this guy's guilty. He probably, I don't know. I wasn't.
Now, look,
there.
I'm not saying
He's
that applies to this case. I'm not saying that this guy is,
Right.
you know, I'm not trying to be, but there are.
But go ahead and try this case. Get in front of a jury and have her say everything I said was an absolute lie. I wanted to manipulate the situation, and that's it. And that's your only witness. And you have a burden beyond a reasonable doubt. There's a good chance he's walking with an NG.
Right. You got to get something. Right.
You know, so people think that Deborah caved there. She didn't cave. You're playing a rough hand.
Right.
On these DV cases where they're not sticking with you, and she didn't have. I mean, I'm glad she didn't. But if she had broken bones or like a big black eye and some more like objective sort of stuff, but like we have a mark on the neck, that is explainable. He could have just choked her like she said, and I think that's probably what happened. Or it could be like not much. And that happens. You're going beyond a reasonable doubt and taking somebody's liberty. That's a tough thing to prove.
Now, this guy's. I mean, look. Let's say dirty. This guy's.
Oh,
I mean, if she had cooperated, this is a slam dunk. With the body cam footage, their 911 call. If she had cooperated, this guy's going up the river, and his attorneys. You know, this never.
Absolutely. Absolutely. You know. But with her throwing reasonable doubt into it, saying I made it all up, absolutely undercutting all the evidence you have. Right, it's not easy. You can still do it. You can. I've seen on prosecutions with adverse victims, and I've seen people get convicted even because the victim was absolutely lying to protect them. I've seen it happen, but it is not easy.
Oh yeah, I mean
but then the other thing is her credibility shot. But she could. Who knows? Maybe she'd make it all up. She's lying at one point. She's either lying today or lying then.
Right, and that's why I think there's risk for for the prosecution for Debbie.
I have my suspicion that she was lying today on the stand as opposed to the trooper. But I wasn't there. Could be the other way around. Honestly, I don't know.
Right.
Oh, it's a wild one. Thanks for coming in. That was a heater of a case. Not a very fun one. I didn't get to use my goat. Okay, I'll use it now.
Oh man, yeah.
So and you've had these DVs, huh?
Oh yeah. Oh my goodness. Yeah, and it's rough, especially early. Speaking Spanish. There's immigration consequences too if you have a domestic violence, even though it's a misdemeanor. In most instances, it's what do you call it? What's the term they use in a crime of moral turpitude? I think is the verb in immigration law. So it has, if you're not a citizen, it's harsher, possibly consequences. Than
you know what you can do though. I've seen this in Nevada. What you can do is you can get all the judges disqualified.
Oh yeah,
and then it works out for you. Well, I've seen it attempted.
But it was successfully completed in someone's family law case, and I think that's why they were emboldened to try and attempt it again.
Yeah, like one time, and even that wasn't like you're right on the merits. It's like we don't feel like dealing with it. Fine, here's another judge. Oh, good Lord. All right. Well, thank you for coming by. Thanks, everybody, for coming by. I didn't know about this. It's Lauren the Pet Lover's fault. Yeah. I had just done the stream. And then they tell me, and I'm like, I got to do it.
Got to do it. Hey, tonight, it's going to be, I do have a real live Las Vegas headliner. It's going to be tonight at 9:00 Pacific. So if you're in the East Coast, take a nap so you can stay up late. So I will be going live later tonight.
9:00 Pacific?
Yeah. So maybe catch you can catch it tomorrow morning if you can't stay up.
You gonna have showgirls?
No, but I do have an award-winning Las Vegas headliner who will be here tonight.
Oh, fantastic!
Yes.
Oh, now I'm curious. Way to tease it.
Yeah.
Tease it, Ben. Tease it.
I've been accused of being a tease, but I don't know.
All right, brother. Thanks for coming by. Thanks, everybody, for coming out. I swear I'll stop streaming today. Bye.
Bye.